I saw the record of the accused person, which he filed my son this month. This court had given the accused opportunity to put all his concerns in writing so that court is able to address them. Since he still wants to address court as per that record, let him go ahead and raise his concerns.
Thank you, my lord, and a very good morning once again. Concerns we wish to raise are two very small concerns. I'm grateful that you've granted us the opportunity to do so. We are not just being insisting on this for now. To be honest, I hope you appreciate that. For example, if I want to communicate my anguish cannot be written, can only be seen on me. And so it's important that I speak. Just to give it a small background, it's a concern about our presence in this court. And the background is that we visited Nairobi, Kenya on the 16th of November last year as a normal visit to our airport here, the International Airport, looking for our hotel. Shortly thereafter, prior to the meeting, we were grabbed by armed men who introduced themselves as Kenyan police, and we were instructed that we were under arrest. We were bundled from the meeting room into a vehicle. And apart from a short stop at a petrol station to fill their tank, the vehicle were abandoned in only stopped in Maraba, where after a short stop on the Uganda border, Uganda-Maraba police, where after a short while another vehicle came and we were put into it. Given a straight marking the military barracks. So the first background to this is that we are really kidnapped and brought back to Uganda by force and detained in a military barracks. We are not soldiers. Where we were held incommunicado for 4 days. So the history of being here is that illegal rendition and detention in the military facility outside the law. From there, we were produced in the military court-martial. A court-martial that had been already declared unconstitutional several times by the Constitutional Court. So we are taken to a court that was illegal in the knowledge of the state, but it was an illegal court. And it is that court that remanded us to Zira prison where we still are. Of course, as everyone knows, the court was later on in January conclusively declared illegal and unconstitutional and scrapped. We remained in illegal custody after the court had declared, the court that remanded us as unconstitutional. Because the remand warrant we were given, it was Priscilla expired. We had expected that following that judgment, if they still wanted to prosecute us, they would take us to the police station and a new process would begin. But we remained in illegal detention until we were charged in Nakawa in February this year. It is the Nakawa court that indicted us. It is the Nakawa court that indicted us on the 29th of May of this year. And I have a copy of the indictment here. I don't know whether it is deep. This is on the 29th of May. Take notice that you will be tried, that is the three of us, A1, A2, A3. Take notice that you will be tried on the above indictment at the sessions of the International Crimes Division, the High Court, the Ordinance, and so on and so on. So we were indicted to be tried at the International Crimes Division. Which is a division of the High Court that is very different from this one by composition and by its processes, procedures. So, the reason I give the background of the illegality that we have faced in the last about 1 year is that we seem to be in another wrong court. process that will just keep us delaying to have this matter disposed of. Second matter, my Lord, is that before the summons or the warrant bring us for in this trial, we had appeared before you in a matter of our application for mandatory bail. And arising out of the ruling that you made, which ruling seriously stunned us. Because especially in your ruling, my Lord, you indicated that the court was not aware of matters to do with our earlier charges in the court martial, the general court martial. There was no record of the charge sheet and the case number. There was no record of the remand that was obtained. All that was available to you was the case since the court can't be an investigator to find out what happened before. To make the conclusions that we see. This was very disturbing because not only were all the documents and details of the general court martial process filed together with our application, the very affidavit that we saw is myself, my colleague, friend here, Ajabade from Tare, both affidavits indicated how we had been arrested in Nairobi, how we were brought to Kampala, how we were charged in the court martial and sections of the affidavit that I am referring to were concurred with, were accepted as truth by the prosecution. Were not contested. Of course, on top of that, our lawyers here in open court made extensive reference to those very documents and to more than even what was free. So, my Lord, we considered that your treatment of our application either showed that either you are grossly incompetent, you could not read what was filed before you, or at least biased. Both of which we consider to be very serious matters, because we run court, everybody looks at court as a temple of justice. And so, my Lord, we were compelled to file a complaint against you with the Uganda Judicial Service Commission. And if you have not received the notification of that complaint by the Judicial Service Commission, as they are required to extend it to you, I'm sure you will receive it. And so these two issues tie up. In this case in which we are charged to be in another court, we end up still in your court. trial, you have set aside today here our second bail application today. This was the application we made in April this year. My Lord, in your ruling regarding the mandatory bail, you categorically stated that it is my considered view that priority be given hearing the main case other than bail applications. In other words, you already have a view about bail applications, that they are useless. What is important is hear the case. I've expressed that view in the writing under the court seal. But we are here today so that you also hear another bail application. Maybe that's why our case also ended up here instead of the court where it was supposed to be, so that we are sure now that the trial has begun and the applications for bail are redundant. So in summary, my Lord, we seek to understand why we are not in the International Crimes Division where we were indicted. And the two, whether and two, my Lord, whether in light of what just said about my complaint, our complaint, my complaint of my colleague, that obeyed me today, against you, which complaint in fact seeks one of the things that would achieve would be to remove you from the office of judge. Whether in those circumstances you consider that it is still prudent continue with the processes of establishing justice for us. That's on the road that constitutes lie and murder. That's what constitutes the concerns my colleague here had today and myself wanted to present to you. As I have said, they are matters of very, very grave concern. We've been in jail for nearly a year now. We are not young people that can be easily adjustable. We have lost so much personal labor that we could be doing. Yeah, so, my Lord, I'm grateful that you have allowed us finally to present these concerns to you and to this court. In case the Judicial Service Commission has not extended our complaint to you, I have a copy here which you can grab and very you, my Lord. Also has a constant here.
My Lord? Counsel Simon Masuka, okay for it? Etu, that is Captain Emish Oya Ola. My Lord,
order we had to debate A1, then Captain Ola A2.
I think, my Lord, you're very right with that, because even if there was a production warrant order, lying in that way, it doesn't change.
if remember I'm guided, pursuant to your decision to accept A1 to mention these concerns for this court. In the same spirit, I pray that you at least accept the three mention these concerns for this honorable court. I so pray.